Alright, folks, we got the appeal. So, here it is. The appeal from orders Circuit Court, Manitowoc County, Angeles-Sikowitz before Neubauer, Riley, and Davis. Per hearing and opinion may not be cited in court. The state presiding authority accepted a limited purpose. Per Sam, 2007, following a jury trial, Stephen Avery was convicted of first-degree intentional homicide, party to a crime, and possession of a firearm by a felon. We affirmed his convictions on appeal. The issues of the new case concern collateral proceedings, whether the Circuit Court erred in denying Avery's motion and two supplemental motions without hearing, as well as the motions to vacate and for reconsideration of the first of these motions. We hold that Avery's 97406 motions are insufficient on their face to entitle him to a hearing, and the Circuit Court did not erroneously exercise district in denying motions vacate reconsideration accordingly. We affirm. Overview. We previously summarized the facts of this case in a decision in Avery's direct appeal, and we will discuss below the facts relevant to the collateral attack and his conviction. But for context, the case began in early November 2005 with the appearance of Teresa Halbach. A 25-year-old professional photographer and volunteer searchers found Halbach RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Avery and other family members lived and worked. It was believed the Halbach had photographed vehicles at the site several days earlier, per Avery's request, according to the state witness Bobby Dassey. Halbach was last seen walking towards Avery's trailer. After finding the RAV4, police searched the Avery property and over the course of the next 4 months discovered identified evidence including burned bone fragments in and around the burn pit with DNA matching Halbach's, both Avery and Halbach's blood, and the RAV4, and remnants of electronic devices and a camera, the same models as Halbach's, in a burn barrel. Halbach's RAV4 key in Avery's bedroom and Avery's DNA on it. Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Avery's sweaty hands, and a bullet and bullet fragments in Avery's garage containing Halbach's DNA. The case was tried over a 5-week period in February and March of 2007. The state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned electronics and camera, cremated Halbach in the burn pit, transferred the remains of the burn barrel, and hit the RAV4 until he could crush it in Avery's car crusher. The defense argues law enforcement was biased against Avery, who was pursuing a wrongful conviction lawsuit against Manitowoc County and the Sheriff's Department, and as a result planted evidence implicating Avery. The real killer, the defense argued, took advantage of the investigation bias to also plant evidence at the Avery property. Once early media publicity made it clear that Avery was set to a key suspect, the jury found Avery guilty of the first-degree intentional homicide and felon in possession of a firearm. Avery received a life sentence without the possibility of extended supervision. In 2009, Avery commenced a direct appeal by filing a motion for post-conviction relief, pursuant to Wisconsin State Statute 97402, requesting a new trial. The motion was denied. Avery appealed. The court affirmed the aforementioned decision. In 2013, Avery filed a pro se Wisconsin Statute 97406 motion, requesting a new trial. The motion was denied, and Avery appealed. The appeal was stayed and later dismissed on Avery's motion. Shortly after initiated the post-conviction proceedings that they're subject to appeal in 2017. Avery filed the first of 6 months motions that are subject to appeal. The motions will be analyzed individually. Further discussion of relevant law, but some basic principles apply generally. It provides a mechanism for vacating, setting aside, correcting sentence once the time for a direct appeal has passed. A constitutional jurisdictional grounds are where the sentence was in excess of the maximum authorized by the law is otherwise subject to collateral attack. Footnote: Avery's appeal is from 2 orders. The Circuit Court's October 3rd, 2017 order denying his June 2017 post-conviction motion, and the court's November 28th, 2017 order denying his motions to vacate and for consideration of the June 2017 motion. We addressed these motions 1 through 3. After filing his appeal, Avery moved to supplement appellate record and no stay the appeal or amend 2 separate motions. We retained jurisdiction and directed Avery to raise his claims to the circuit court and form supplemental post-conviction motions. We addressed these motions 4 and 5 in April 2021. Avery filed a motion in the court to stay his appeal and remand. We have not yet acted on that motion, so we addressed to decide the motion number 6. Reviewing requires the defendant to raise all grounds for relief in his or her first post-conviction or appellate motion. States Merpaletti. Thus, a defendant is normally barred from raising issues in 97406 motion that could have been raised in direct appeal and previous. An exception to this rule exists where the defendant can show sufficient reason for not raising the issue in prior post-conviction proceeding. Whereas here, defendant appeals the circuit court's denial of Wisconsin motion without an evidentiary hearing, the question before us is narrow. Whether to remand the hearing is warranted because the circuit court erred in denying the motion on its face. The court shall, unless the motion and the files are records of the action, conclusively show that the defendant is entitled to no relief. Our Supreme Court has determined, however, the baseline level of specific applies to the post-conviction motions, including those under 97406. Thus, in order for reviewing court meaningfully access the claim, another footnote, all grounds for relief available to the person under the section must be raised in the defendant's original supplemental amended motion, and ground finally adjudicated or not just raised or knowingly, voluntarily, and intelligently waived in the proceeding that resulted in the conviction, the sentence, or in any other proceeding. The person has taken to secure relief may not be base for subsequent motion unless the court finds a ground for relief asserted which sufficient reason was not asserted or is inadequately raised in original supplemental amended motion. Defendant must allege sufficient material, who, what, where, when, why, how, that, if true, would entitle to the relief seeks. The requirement promotes finality once the defendant has been convicted and sentenced. Minimize time-consuming post-conviction hearings unless there is a clearly articulated justification for them, and recognizes that the plea and proof burdens have shifted to the defendant in most situations. And after conviction, accordingly, in the context of 97406 motion, the defendant must describe with specificity his or her sufficient reason for failing to raise the claim. In an earlier proceeding, that is, the defendant must show why his or her claim is not procedurally barred under the 97406. We will further discuss some of the contours of the sufficient reason exception below, but one point bears mentioning here: an ineffective assistance of post-conviction counsel can be, and often is, cited as for a reason for the defendant not bringing some claim on direct appeal. The specificity requirement, however, applies just as much as this context. The defendant cannot merely present legal conclusions, summarily arguing the post-conviction counsel was ineffective for failing to bring the claims he or she now views as meritorious. Instead, to be entitled to a hearing, the defendant must raise sufficient material facts demonstrating prior counsel's ineffectiveness. That is, that the counsel was continuously deficient and that such performance was prejudicial to the defendant. Importantly, to show a deficiency in the context, the defendant must allege sufficient facts showing that his or her new claim is clearly stronger than the claims post-conviction counsel in effect above. Whether the circuit court erred in not ordering a hearing involves 2 potential inquiries, which separate standards for review. The circuit court must hold a hearing where the motion is sufficient on its face, unless the record as a whole otherwise conclusively demonstrates the defendant is not entitled to relief. This isn't looking good. Whether Wisconsin statute motion meets the standard, including whether this is sufficient reason for overcoming the procedural bar, is a question of the law that we review de novo if, on the other hand, the motion does not raise sufficient facts or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief. The Circuit Court has discretion to grant or deny a hearing. In such case, review of the erroneous exercise of discretion. In August 2016, Avery, now represented the counsel, brought motion post-conviction scientific testing. In November 2016, the Circuit Court granted a motion permitting Avery to conduct independent testing on 9 trial exhibits, 7 samples of blood stain cuttings, swabs, blood flakes taken from Holbach's floor. That's the thing I went over, the letter to Judge Sook and stuff. And she also submitted her 1,000-page document, and then Judge Sook just dismissed it when she was trying to request to retest everything. But based largely on the results of this testing and other investigations, Avery filed Wisconsin 9706 motion in June 2017, requesting a new trial. His motion raises a number of claims failing into 3 categories for purpose of overcoming procedural bar. First, Avery alleges that trial counsel was ineffective for failing to fully investigate or present expert testimony in support of his theory that he was framed. Second, he brings several claims based on alleged Brady violations. Third, he raises claims on results of the new investigation of a bullet, the hood latch swab, RAV4, RAV4 key, and of which characterizes newly discovered evidence. The Circuit Court found that most of these claims were procedurally barred under Escalante and Hernando because Avery had not alleged a sufficient reason for not raising them in the 2013 motion or in a direct appeal. The court further held the claims based on new scientific tests, which considered the context of the full record, did not allege sufficient facts that, if true, would entitle Avery to relief. The court noted that the new reports on the bullet, hood latch swab, and key were equivocal in conclusions and ambiguous. Therefore, given the totality of the evidence submitted at trial, it cannot be said that the reasonable probability exists that different results will be reached in a new trial based on these reports. Accordingly, the court denied Avery's motion without hearing. Reviewed the sufficiency of the motion de novo, and we determined that Avery was not entitled to a hearing as a matter of the law. We then reviewed the Circuit Court's decision to deny him a hearing, erroneous exercise of their discretion. The first threshold step in the analysis is determining whether Avery has stated a sufficient reason for not raising the claims in his 2013 motion on direct appeal. Ineffective assistance of trial counsel. Avery's claims relating to the ineffective assistance of trial counsel are not and cannot be based on a new or newly discovered evidence unavailable to trial counsel. By definition, these claims are based on alleged errors of trial counsel, the argument being that Avery was thereby denied the constitutional right to counsel. As with any 9706 claim, Avery must show that there was a sufficient reason that these claims were not raised in a direct appeal in his 2013 pro se motion. And to establish sufficient reason for not raising an ineffective assistance of trial counsel claims on direct appeal, Avery must show that his new claims are clearly stronger than the claims post-conviction counsel actually brought. We began considering whether Avery had shown sufficient reason for not having raised these claims in his 2013 pro se petition, which then turned to whether Avery has shown a sufficient reason for not raising these claims on direct appeal. It is in the point that analysis dovetails with the merits of Avery's ineffective assistance of trial counsel claims, because his new claims are facially inefficient as a matter of the law, and the post-conviction counsel cannot be ineffective for failing to raise them on direct appeal. Therefore, we analyzed the potential procedural bar of the 2013 petition. We turn directly to whether Avery's remaining claims demonstrate reasonable probability, but the trial counsel unprofessional errors, he would not have the convicted trial. Sufficient reasons for failure to raise the claims, 2013 motion. As a starting point, although Avery may argue ineffective assistance of the post-conviction counsel is a sufficient reason for not raising the claims on a direct appeal, the argument is not available to excuse failings in the 2013 motion. That is because Avery did not have a constitutional right to counsel following his direct appeal. As our Supreme Court recently observed, there is no constitutional right to counsel on a collateral attack, and consequently, the vast majority of Wisconsin 97406 motions are filed by pro se litigants. The exception would swallow the rule if there were assertion for pro se status were sufficient to overcome the procedural barrier of Escalante. This legal point precludes excessive post-conviction motions from turning into something akin to Russian nesting dolls. There they go with these stupid analogies. Whether a litigant can simply allege continuous, serious, and effective assistance of counsel claims to justify previous failures to raise an issue instead, where there are successive 97406 motions, and new motion must be based on something other than ineffective assistance of post-conviction counsel. Avery appears to recognize the point foregoing any claim based that mere fact that he was without counsel. Nonetheless, his June 2017 motion largely focuses on the quality of his self-representation, providing the following jurisdiction for not raising any of his current claims in his pro se 2013 motion. Numerous unique circumstances present here provide sufficient reasons for the current claims were not previously presented. Mr. Avery had no way of knowing the factual legal basis. The claims he set forth herein as learning disabled indigent prison, Mr. Avery simply could not have known them. His attempt to file materials pleading was thwarted by his lack of legal knowledge. The current motion is a product of over 1,000 hours of attorney time, hundreds of hours expended to private investigators, numerous consultations with experts, funds to retain the experts, and more. Expect an indigent prisoner acting pro se to compile a materious motion under the circumstances would be understandable. Mr. Avery's lack of legal knowledge, cognitive deficiencies, and complexity of the unique case provided sufficient reason for that current claim should be addressed in the merits. Thus, we construe Avery to offer 6 somewhat overlapping explanations that taken together might provide sufficient reason for not raising his claim in 2013. He was unaware of the legal basis for his claims. He was unaware of the factual basis for the claim. He was acting pro se. He was indigent. He is a learning disability, and the case is particularly complex. Yeah, that's an understatement. These explanations do not justify Avery's failure to bring the majority of the claims. Again, the quality of Avery's representation in a prior motion cannot, in of itself, constitute a sufficient reason for not raising any issue earlier. Accordingly, we reject Avery's first argument that he lacked awareness of legal basis for the claim. Lack of awareness and legal basis for the claims, a term of art that does not merely mean that Avery was not a lawyer or lacked legal knowledge. Rather, it means that he could not previously have anticipated a change in the substance law that opened a new basis for a collateral attack. Here, Avery claims are based on well-settled law. As the reasons 2 through 6, Avery gives us bare-bones factual conclusions, but does not meaningfully explain why the circumstances he describes preclude him from raising most of these issues earlier. Regarding reason 2, unawareness of the factual basis of the claims, Avery does not explain. We cannot envision why he did not have all the facts necessarily in 2013 to raise these claims, which, after all, are premised to the further investigation of evidence and witnesses known to Avery at the time. As to 3, explained above, a defendant's pro se status standing alone cannot excuse his or her failure to raise claims in a motion. With one exception discussed below, Avery's remaining reasons are similarly deficient. Avery simply claims that he is learning disability and was indigent in 2013, that his case is complex. He does not cite any law or develop any detailed argument as to why these facts alone are taken together. Explain his failure to raise these claims. It appears well established as federal habeas law, for which we can borrow, that reasons such as there are not sort of grounds procedurally barred can be avoided. Retardation or organic brain dysfunction did not provide sufficient cause to excuse procedurally default or ineffective assistance claim. Cause may be based on external impediment. The one exception will be recognized concerns Avery contention that on his own it would have been impossible for him to undertake the extensive investigations later carried out by current post-conviction counsel.
Okay. Can you hear me?
Yeah, hold on, I'm reading. He framed additional...
It was Davis wasn't out. Davis was still in.
I know, I'm still reading this. I'm live, Cap. But to do a chance of success, he would have alleged the post-conviction counsel ineffective for not raising ineffective assistance trial counsel claims on the basis. And to succeed on the claim, he would have had to show that his new claim was clearly stronger than those actually brought in direct appeal. Absent forensic testing supporting the basis for such a showing, this would be an all impossible task. Thus, unique circumstances might exist wherein a pro se defendant is unable to perform or pay for an investigation, but later gains the resources to uncover new material facts and develop alternative theories for the crime, and on the basis can claim sufficient reason for not previously raising claims based on these theories. We do not perceive policies underlying, namely, the need for finality in litigation preclude this result. Indeed, to hold otherwise could unfairly punish defendants who bring post-conviction motions based on all facts known or reasonably discovered by them. Purposes claims based on a newly conducted investigation which could not have been previously undertaken would appear to be little different than the claims based on newly discovered evidence, and we will treat them as such, determining whether they are procedurally barred by the virtue of Avery's prior pro se post-conviction motion. That said, the majority of Avery's ineffective assistance of trial claims are not based on investigations that Avery, now represented in counsel, was only recently able to perform. On the other hand, we have identified, I'm just going to skip the footnotes. I'll put the link to this thing in the video if you guys want to read this yourself, but I'm sure you'll be able to find it everywhere. Some claims are premised in results of the forensic testing that could convincingly fall in this category, so as to address as nearly as allowable the merits of this motion, we will assume that Avery has alleged sufficient reason for not raising these 7 claims in his 2013 motion. The claims are the trial counsel ineffective for failing to present the blood spatter expert who have found Avery's blood was planted in a RAV4. Present the blood spatter expert who had found a hollow box was not thrown in the rear of the RAV4. And present the blood spatter expert who would have determined that the theory counsel presented at trial as to how Avery's blood was planted in the RAV4 on the table. Present the trace materials expert who would have found the RAV4 key recovered from Avery's bedroom was hollow box sub key and secondary key. Present the DNA expert who would have found that Avery's DNA was planted in sub key by the enforcement. Present the DNA expert who would have found that Avery's DNA was planted in a RAV4 hood latch, and present the forensic fire expert who would have found that Hellbox's body was not burned in Avery's burn pit. Merits of the Avery claims ineffective assistance of trial counsel. We now turn to whether Avery's ineffective assistance of trial counsel claims have alleged sufficient material facts. Who, what, where, why, when, how, that if true, when entitled, bearing in mind that it's not entitled to a hearing where the record conclusively demonstrates otherwise. Avery must show that hearing would not be frivolous. Avery cannot make these showing. First, he has wholly failed to demonstrate deficient performance. The trial counsel's representation fell below objective standard reasonableness. Counsel's not retaining experts similar to those he later retained. Avery apparently assumes that his findings speak for themselves and that, given the strength later claims it's necessary for such experts should have been obvious at the time of trial. Avery also assumes, again without explanation, that any experts retained by the trial counsel would have reached the same conclusion as his later experts. But even accepting these premises, Avery has not demonstrated prejudice that there is a reasonable probability, but for counsel unprofessional errors, the result of the proceeding would have been different. Avery's first three claims: trial counsel failure to retain blood spatter expert. Avery argues in a motion that counsel was ineffective because of such expert would have found this blood was planted in the RAV4. These are trained experts' actual findings, however, are not nearly so conclusive. The expert did not conclude that Avery's blood was planted or rule out Avery was the source of the blood. Rather, he determined that the presence of Avery's blood was consistent with being randomly distributed from a source, because his blood is present in some locations but absent in some others. Sorry. Reasonably inspected locations and absence of blood stains. These locations inconsistent with Avery with active bleeder. The state alleged at the trial that Avery Stringer was actively bleeding while he was in the RAV4. Expert further determined that the blood stains were consistent with explanation other than Mr. Avery being in the RAV4 and depositing his blood in those locations with the actively bleeding cut finger. Certainly, these conclusions trend support Avery's general theory that he was framed, and the presentation may have been useful at trial. But Avery's burden in post-conviction motion is not merely to point out helpful evidence, but show how the introduction at trial could reasonably have led to a different outcome. He cannot meet this burden by misrepresenting the expert's results as demonstrating that he is framed. Absent additional facts of the argument, we cannot assume that such measured... Yeah, this isn't looking good at all. Alternate finding as how she was killed supports his theory that he was framed. Third, Avery contends that the blood spatter expert could have advised counsel that the trial strategy for explaining the presence of blood in RAV4 was flawed. This assertion entirely speculative as a matter of law. Such guesswork falls well short of demonstrating ineffective assistance of counsel. Fourth, Avery argues that counsel was ineffective for not retaining trace material experts who had found RAV4 key recovered from Avery's bedroom, Hallbox secondary key, sub key, but it is again completely speculative. Assume that the sub key was therefore planted, and not instead the Hallbox herself was using the sub key and not her main key on the date of her death. After the fifth and sixth claims concerned retaining a DNA expert, according to Avery, such an expert would have determined that his DNA was planted on the key by law enforcement. Avery again mistakes that the evidence his expert analyzed DNA from the Excalibur key, reportedly held by Mr. Avery as if to start a car, gripped by ungloved fingers for 12 minutes. The expert determined that 10 times that less DNA was deposited on the Excalibur key than on the key recovered by the law enforcement. The expert further concluded that the key was indeed enhanced, that it is likely that some personal item of Mr. Avery's was used for this purpose, such as a toothbrush. Side note, his toothbrush went missing and it was found by Jody underneath the sink. Or a cigarette butt. Thus, Stephen didn't smoke though, so yeah, okay. Thus, once again, the finding of the Avery's expert is significantly more ambiguous than what presented in the motion. We have no reason to doubt the truth of these findings, although we note the expert did not observe Avery holding the key, but simply determined Avery deposited sufficiently less DNA in a controlled experiment, does not indicate that Avery could not or did not deposit more DNA under other conditions, and it certainly does not demonstrate that law enforcement planted DNA on the key. Thus, even accepting the truth of these new findings, we cannot conclude that there is reasonable probability that their introduction in a trial would have led to a different result. Avery's sixth claim is counsel was ineffective for retaining a DNA expert who would have determined the DNA from Avery's sweaty hands was deposited by Avery on the RAV4 hood latch, demonstrating that Mr. Avery was being framed. In what is becoming a pattern, Avery has misrepresented the facts. The DNA expert Avery has now hired did not determine that Avery never deposited DNA and did not state that Avery was framed. Instead, the expert performed a series of experiments on an identical vehicle wherein volunteers opened the door hood using the hood latch. Only 4 of the 15 volunteers positive DNA, and those 4 deposited significantly less DNA than present in the swab from the Halbach RAV4 hood latch. From the experiment, the expert exploited that the possibility that the law enforcement could have retrieved reliable swab of Avery's groin, which was collected and discarded from exceeding the scope of the search warrant, as many from the hood latch. The expert admitted, however, that the convenience of the explanation and the fact that it accounts the physical findings observed from analysis does not prove evidence tampering or more precisely evidence reassignment. Thus again, we are left with the facts that even true, would not entitle Avery to relief. In controlled experiment, minority of volunteers deposited sweat on the RAV4 deposited significantly less sweat than on the swab recovered by law enforcement. There's no context to these findings, no showing of why Avery, under uncontrolled conditions, could have not deposited more sweat than the volunteers, much less any showing the DNA was therefore planted without such context. This evidence is not exploratory and even particularly relevant, and Avery's attempt to link the alleged reassignment of his groin swab is wholly unsupported by any facts or record. Avery's 7th and final claim to the trial counsel was ineffective for not representing a forensic fire expert who would have found the Halbach's body was not burned in Avery's burn pit. Her bones were therefore planted. Avery's cited factual report, once again, does not live up to the advanced building. His forensic fire expert did state that he disagreed with the opinion that the main destruction of the body took place in the Avery burn pit, but Avery does not explain why. From the conclusion, it follows that Halbach's remains were planted, because it does not explain why himself would have been able to cremate some portion of Halbach's body in another location, including his burn barrel, where additional bone fragments were found. That's not true. That wasn't his burn barrel. That was a Datsy burn barrel. Avery does not explain where or how the prodigious arises, given his own forensic anthropologist testified to the same conclusion at trial. Avery's expert further concluded that, contrary to the state's theory at trial, Halbach's body could have been burned to the extent it was burned in only 4 hours. Again, this is a fact without context. At most, presenting such evidence at trial would have enabled the jury to weigh 2 competing expert opinions on how Halbach was cremated. After again presented a reasoned bias for concluding that the outcome of the trial would have been different, in sum, the 7 ineffective claims in Avery's June 2017 motion, as based in the investigation, failed on the merits. Avery has not shown that trial counsel provided objectively deficient representation by not hiring experts similar to those he later hired. Instead, Avery merely assumes that the need for such experts should have been obvious at the time, based on the later findings of his own experts. These later findings, however, are either equivocal or irrelevant, or both. In addition, Avery has not explained how these findings would have negated or undermined the cumulative effect of other trial evidence. Thus, Avery failed to show that even if all these findings were admitted at trial, the result would have been different. Consequently, Avery has not alleged the sufficient materials, facts entitling him hearing the claims and effective assistance of counsel. Avery next argues that the state withheld favorable evidence in the possession and violation of Brady. His first alleges that the state suppressed a voicemail recording that Halbach left on the answering machine of her photography client, who she met on the same day that she visited Avery's property. Next, he alleges that the state withheld an unedited video of the flyover footage of Avery's property, and instead released the Avery edited version with just 3 minutes of footage. Finally, Avery argues that investigation concealed their knowledge that Halbach's RAV4 was driven onto their property on Avery's next-door neighbor. Avery does not claim that the alleged Brady violations were unknown or undiscoverable at the time of the 2013 motion or direct appeal. He's given an explanation for not raising any of his new claims in the 2013 judgment in relates to his status as pro se prisoner litigant. His explanation for not raising his claims on direct appeal does not reference the Brady claims. Thus, Avery has not overcome his procedural bar, sufficient reason for not raising his Brady claims earlier. In any case, Avery's 2017 motion does not sufficiently allege any Brady violations. A defendant has a due process right to any favorable evidence, material either to guilt or punishment that is state possession. A defendant is entitled to a new trial based on denial of such right by showing the evidence is favorable to the defendant, either because it's exculpatory or impeaching. The evidence was suppressed by state either willfully or inadvertently, and the evidence material, the standard material, is the same as the under prejudice prong. Strickland, evidence is material only if there is reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Avery has not demonstrated any of the above elements for any of his claims, but what is clearest on his face is that the evidence, what even exists, is immeritable. Avery's first claim centers on that on the day Halbach visited his property, she left a voicemail that she could not locate the residence of one of her other photography clients, who she had also visited that day. Avery argues that his voicemail been played at trial, it would have refuted the theory that Halbach's final appointment with Mr. Avery. At trial, however, the photography client testified after Halbach left her voicemail on the client's answer machine, she found the client's house, took photographs, and left within 15 minutes. Then, approximately 20 to 30 minutes after Halbach left the voicemail, other witnesses' testimony placed her as driving to and then on Avery's property. The voicemail is therefore consistent with the evidence, which is Halbach left the voicemail, visited a client, and then visited Avery's property. There is no bias for the assumption that the content of the voicemail would have refuted the state's theory that when Halbach was killed. Avery's next claim that they received an edited version of the flyover video. His property may contain favorable evidence. As far as we can tell, this claim is basically based on only Avery's unsubstantiated belief that a second video must exist, because the airplane was in the air for 4 hours, but the video received was only 3 minutes long. There is no evidence of Brady violation here because Avery, I just want to stop right here. They were in the air for 4 hours. They were flying all over the place. Why don't we have video we just have a short video of them driving down County Road B, and then they're at the Avery property. We don't see them going past Zippers. We don't see them going up and down the freeway, heading towards Green Bay, coming back. I don't know. And it's only 3 minutes. Finally, Avery argues that the investigation knew but did not disclose to him that the Halbach RAV4 was driven onto the property on Avery's next door neighbor, and difficult to follow this argument based on affidavit from the neighbor who did not state the RAV4 was on his property, but rather it says that the conversation with law enforcement agents in which they stated their belief as to Halbach's vehicle was driven onto the property, but the agents could have been referring Halbach's driving route on the day of her death. Avery suggests that the information in this affidavit supports his claim that the law enforcement framed him for the crime by driving the RAV4 through the neighbor's property and planted it on his. This argument is unintelligible, and in any case, we cannot perceive any violation. There was no evidence here to suppress, and the facts in the affidavit are inconsequential. Finally, Avery raises 2 claims based on newly discovered evidence. He contacts the new scientific evidence to demonstrate that the damaged bullet in Mr. Avery's garage was not shot through Halbach's head, causing her death. He also argues that according to the new test, the swab labeled as coming from Halbach's hood latch, containing Avery's DNA, was not in fact taken from the hood latch. In theory, defendants should be able to more easily overcome procedurally bar when basing claims on newly discovered evidence, which after all concern evidence not available in prior proceedings. This is not the case here, however, as demonstrated that simply turning the merits of Avery's claim. To obtain a new trial based on newly discovered evidence, the defendant must show that the evidence was discovered after conviction. The defendant was not negligent in seeking evidence. The evidence is material to an issue in the case. 4. The evidence is not merely cumulative. Another footnote. Let's see. Avery cannot meet more of these elements for either of his claims. Threshold matter. Avery cannot meet shown in particularly new evidence and the fact new. Avery asserts that the equipment yielding his results previously unavailable with new technology and or manufactured in 2016. But aside from thus cursory statements, Avery does not address whether technology available at the time of trial could have yielded the same results. Beyond that, Avery's evidence that is largely irrelevant. The premise of his claim is that if the damaged bullet found in the garage did not deliver Halbach's fatal shot to the head, then he could not be proprietor. But the state never argued that either of the bullets covered from Avery's garage. Hold on a minute. Let me turn this notification off. Did not deliver him. Where was that? Garage killed Halbach. As a trial, the state showed that Avery's gun fired the bullet and that the bullet and Halbach's DNA on it. But the state did not argue that the specific bullet entered Halbach's skull or killed her, nor was it necessary that it do so in order to implicate Avery in her murder. There is nothing to suggest that the shots fired into Halbach's skull were the only shots fired at her, or that the very bullet fired at her contained skull fragments. There were, after all, 11 casings and only 2 bullets found in the garage. It presents that Halbach's DNA on the bullet found in Avery's garage is particularly damning evidence, regardless of whether it was the bullet that entered her skull, and strongly implicates Avery absent evidence that Halbach's DNA was planted. At the very least, Avery's new evidence in the fact is new and consistent with the state's theory of the crime. Avery's next argued that the expert observed his hood latch swab and determined that swab collected from the hood latch of the 2 exemplar vehicles, 2012 RAV4 and 2007 Volvo S60, each shown a considerably heavier loading of debris than the swab from the RAV4 hood latch. The expert apparently reached this result, however, by observation alone, concluding that particles on the RAV4 hood latch swab could only have been seen with the aid of a microscope. A swab from each exemplar vehicle showed a heavy, dark streak of collected debris that is clearly visible to the unaided eye. We are left to wonder how new testing methods or equipment could possibly aid these analyses. In any event, the expert did not determine that the purported RAV4 swab was not used to swab the hood latch, as Avery claims, much less that the swab was reassigned, otherwise used to frame Avery. There is no possibility that the presentation of the evidence would have yielded a different trial result. Conclusion 2017 motion. Because Avery has not shown is entitled to the hearing any claim reviewing the circuit court's denial of hearing for erroneous exercise and discretion, we find that they could not near in the regard agree with the court's assessment that Avery's equivocal, ambiguous conclusions been introduced at trial, there would have been no reasonable probability of a different result. The circuit court properly exercised its discretion. We gave Avery the benefit of several doubts as to why he did not raise these claims earlier. He even considered unmerited. The claims asserted in his 2017 motion are speculative, conclusory, and in some cases misleading. The circuit court did not err in denying these claims without a hearing. 3 days after the circuit court denied his Wisconsin statute, Avery filed a motion for relief pursuant to Wisconsin State Statute 80607. The state bias the motion was that a month prior to the court's order, defense counsel and prosecutors had agreed to additional testing in Hallbox RAV4, and if bones found in the Manitowoc County gravel pit, and the parties had agreed to Avery would amend the 2017 motion, and that Avery intended to inform the court that an amended motion would be filed, but did not anticipate the court filing its order before he could do so. The circuit court denied the motion, explaining that after receiving the 2017 motion, no communication was made requesting that the court withhold its final decision, indicating that the original motion was incomplete and would be supplemented. The court acknowledged that the defense prosecution might very well have discussed amending the 2017 motion in anticipation of the court's granting a hearing, but, it's always a but, provides that the court relieve a party from a judgment, order, and stipulation for mistakes, inadvertence, surprise, excusable neglect. Review the circuit court's decision on the motion for relief under 80607 for erroneous exercise of discretion, meaning we will sustain the court's ruling where it applied appropriate law to the facts on record and reasonable determination. As explained above, Movid is not entitled to evidentiary hearing merely because he or she filed the motion. In the typical case, the circuit court will evaluate the sufficiency of the motion before ordering a state response, scheduling a hearing. Receive and deny motions were there, no bias for hearing, as one expect. Courts are not required to, and generally do not, update the movement about when a decision on the motion is forthcoming. Avery appears to acknowledge these basic principles of post-conviction procedure. Nonetheless, he argues that the circuit court erroneously exercised its discretion here because, in denying its motion for relief, it ignored the existence of the 2007 order. This 2007 order and preservation of blood evidence, independent defense testing, direct the state to preserve swabs, bloodstain samples collected from the RAV4 containing Avery's DNA, also such items submitted independent testing without further order to this court. Avery's argument with respect to the 2007 order misses the mark entirely. Even if all of the items were parties contemplated testing in 2017, having described an order was no bearing on presentation, timing, or amendment of any 97406 motion, the circuit court correctly concluded that it was not required to revisit its decision on a 2017 motion upon being blatantly informed Avery was wished to amend the motion. Thus, the court did not enormously exercise discretion, declining to vacate an order adverse to Avery, so allow amendment of the motion that was filed without reservation. Shortly after filing, Avery filed the motion to reconsider, relevant to his appeal. He alleges that the newly discovered evidence warrants reconsideration of the court denial of the June 2017 motion. Party may prevail in the motion reconsidering and presenting newly discovered evidence, but such motion is not platform to introduce new evidence that have been introduced as part of the original proceeding. Newly discovered purposes the evidence unknown at the time of the final judgment, that is, it was not under the control of acknowledgement of the movement or discoverable or reasonable diligence. Court's decision and motion reconsidered under erroneous exercise of discretion standard. Motion to reconsider the basis for new evidence would seem to be doubtful utility in cases like this, where the movement is free to file successive motions. Nonetheless, we perceive no legal barrier in Avery's bringing such a motion, and the state did not argue as much, except to the point that the motion cannot be the means of avoiding procedural bars. In context to the entitled reconsideration on the basis of newly discovered evidence, the moment must show that the evidence was unknown and not reasonably discoverable when the first motion was filed, and the evidence reasonably relates to these claims brought in this first motion. Alternatively, the moment may simply bring a new motion and demonstrate his or her sufficient reason for not raising the claim to the prior motion by showing the evidence underlying the claim is unknown and unreasonably discoverable. Avery makes no showing in his motion to reconsider as to why he could not, with reasonable diligence, have included the new evidence in his 2017 motion. Instead, he uses his third motion as a vehicle for raising new claims. None of these claims or evidence, however, have any bearing on the claims raised in the 2017 motion, so it is unclear whether the original claims Circuit Court was being asked to reconsider or why. In any case, the majority of the evidence cannot be reasonably considered unavailable or undiscoverable at the time he refiled his 2017 motion, or if simply treat this motion as new. Avery does demonstrate why these claims are not procedurally barred under, let's go in, setting aside the question of why the claims were not alleged in the 2017 motion. Avery has not explained what they were not alleged in 2013 motion or not direct appeal. We do note that buried in the motion are two claims based on evidence that appears on fact the claims to be newly discovered. According to Avery, October 2017, his sister Bob Tadich, who lived at the Avery property with his son Bobby Dassey, Avery identifies as an alternative suspect in a crime, told him two pieces of information that would impeach her son's testimony about last seeing Halbach walk around Avery's trailer on the day of her disappearance. In Avery's view, his sister admitted that she knew that Halbach had left the property on the day in question. This evidence, however, is equivocal and does not clearly establish Halbach in fact left the property on the day of her death, or that any witness is aware of the lie about this fact in trial. Moreover, the evidence does not bolster any claim in the June 2017 motion. Another footnote, it's also the whole little spurt of conversation between Barb and Stephen right before they interviewed Bobby in 2017 when they opened up their Queso 2.0 bullshit. Even viewed in his own merits, the evidence does not entitle Avery to hearing because he has not shown that his material. We have two unsworn statements by Barb Tadich and the Dassey told her something that is potentially inconsistent with the trial testimony. This is hearsay that would be inadmissible at a new trial, meaning that it cannot constitute newly discovered evidence, a matter of law. Avery chose to frame the claims as the context in the motion can reconsider without applying to the legal standard or explaining why he had sufficient reason for not bringing the claims previous motions. As discussed in the above section, again, it's the little transcript of the conversation. In June 2017 motion, we were willing to give Avery the benefit of the doubt where possible as to why he did not raise certain claims in 2013 or on direct appeal, but we cannot ignore the law, thus we cannot simply determine whether the merits of the motion to reconsider claims warrant an evidentiary hearing. For the only question before us whether the Circuit Court erroneously exercised its discretion in reconsidering the June 2017 motion on the basis of perpetrated new evidence contained with these claims. We conclude the Circuit Court did not erroneously exercise its discretion in denying the motion. The court noted that Avery provided no explanation for filing the 2017 motion, while a considerable investigation was still being conducted by the defense. More footnotes. The explanation is reasonable and sound represents the appropriate exercise of discretion. Motion number 4, July 2008 supplemental motion. Avery applied for Circuit Court 2017, November 2017 orders denying his June 2017 motion and his motions to vacate and reconsider, respectively. In May 2018, Avery moved to court directly to supplement the record appeal with a CD disclosed the defendant the first time on April 17, 2018. Avery asserted the supplemental appellate court record was appropriate because the context of the CD related to the claims already presented to the Circuit Court. We say that the assertion misses the point, which is we are not a fact-finding court and cannot consider items not presented to circuit court. We determined, however, in July 2018, Avery filed a motion, supplement motion, alleging Brady violation and recalled as prior to trial. Avery successfully moved to introduce third-party liability evidence. Motion, Avery alleges the state without significant evidence, both favorable to his Denny motion, relevant to the impeachment purposes. In final investigation report, Detective Mike Veely saved on a CD, the Veely CD. Veely created the report through forensic examination of the hard drive of the computer used by Dassey, who Avery identifies as possible Denny suspect. Veely's CD contains thousands of images of violent pornography that Avery argues relevant to propensity of sexual violence. Avery also attempts to explain why several people who used the computer, only Dassey could have downloaded those images. The CD is also contained a timeline that purportedly impeaches in criteria word searches, registry, recovered pornography, internet history, Windows registry, and all MSN messages. According to Avery, he did not receive the Veely CD until April 2018. It's true because Fassbender had it tucked away. The question is, what else did they still have hiding? The circuit court determined that there was no Brady violation because there was no evidence suppressed. We agree it is undisputed that the computer was examined and its contents copied to 7 DVDs, and disputed that the Avery counsel received these 7 DVDs prior to trial. Finally, it is undisputed that the limited and irrelevant expectation that the Veely CD does not contain any additional information that was not on 7 DVDs. Consequently, the Veely CD is not suppressed evidence, but merely investigating summary evidence provided Avery. Yes, but the prosecution, when they turned these items over to the defense, they led them to believe that there was nothing of significant value on them. And they weren't given all the time in the world to go over everything. So they're not taking everything into consideration, my opinion. But I could be wrong. But my opinion don't matter. Anyways, Avery appears to acknowledge the facts in the appeal, but argues that he should have access to information derived from Veely's unique word searches, pornographic images, refined relevancy, and like. This is not the law. Brady on its terms applies to the favorable material of supposed evidence. Avery has presented no authority extending the principle of prosecution's withholding secondary complaints analysis as such. Brady applies only to the facts not already known to the defendant. The government need not facilitate the compilation of the exploratory material, which some industry defense counsel could marshal on their own. More footnotes. In July, Avery raises 2 related arguments concerning the disclosure of the DVD himself. He argues that the state deliberately misled him about the importance of the DVDs by stating in an email that he did not include much of the evidentiary value, even if the statement mischaracterized the evidence. However, an off-the-cuff description of disclosed evidence cannot form the basis for a Brady violation. Avery further argues that he was not provided the DVDs approximately 1 month before the Denny hearing, leaving him completely impaired in his ability to introduce relevant evidence in the proceeding. But this argument properly concerns alleged ineffective assistance of trial counsel, because such conclusive statements did not adequately explain why trial counsel did not have analyzed the DVDs in time for the motion hearing, sought to postpone the hearing, or taken any number of steps to effectively leverage this evidence. In July 2018 motion, Avery does indeed argue that the trial counsel was ineffective for failing to forensically examine 7 DVDs prior to the trial. He does not similarly, however, in a manner that leaves us unable to meaningfully analyze the claim regarding the potential use of evidence in this Denny motion. Avery does not address the prejudice prong Strickland test, which in our view encompasses at least 2 inquiries that made evidence the trial Dassey could have killed Halbach. Avery would have had a providence evidence at the pretrial Denny hearing directly connecting Dassey to the crime. Evidence that another party committed a crime may be admissible pursuant to Denny, and the defendant can show third-party motive, third-party opportunity to commit the crime, and some evidence directly connecting third party to a crime. The Dassey possibly possessed violent pornography images might have conceivably satisfied a separate requirement, motive, but insufficient on itself, and to allow admission to third-party liability evidence. Avery failed to meet the direct connection requirement in its original Denny motion and not presented additional evidence on the point in motion. Thus, even assuming the trial counsel was deficient in not analyzing the DVDs, Avery cannot demonstrate reasonable probability of a different outcome at the hearing. Regarding the use of evidence impeachment purposes, even accepting the CD contains a timeline that impeaches Dassey trial testimony, we are skeptical at this point. Avery does not explain how impeaching Dassey about his use of the computer would have changed the outcome of the trial. At most, the jury would have disbelieved Dassey's testimony that, on the day Halbach last visited Avery property, he saw Halbach walk towards Avery trailer. He did not see her leave the property. Halbach RAV4 was in the driveway when he left to go hunting. The RAV4 was gone when he returned several hours later. Avery identifies the key pieces of testimony. Certainly the testimony bolstered the state's theory that the Halbach visited Avery on that day and did not leave the Avery property thereafter. But absent this testimony, the state still possessed sufficient forensic and evidence implicating Avery in a crime committed on his property. Without any showing of argument into why the impeachment of Dassey would have undermined the cumulative effect of other evidence, we cannot conclude that the trial's outcome would have been different. We conclude the Circuit Court did not err in denying the July 2018 motion without a hearing. Yeah, that's not good. March 2019 seventh motion. In January 2019, Avery again moved his court directly to state appeal remand to the Circuit Courts considering specific claims relating to the state's 2011 release of Halbach's family of suspected human bone fragments. We determined that, given the specific circumstances of this case, we would stay the appeal and remand pursuant for action of this issue. We again ordered remand to the Circuit Court to permit Avery to pursue a supplemental post-conviction motion and specific claims, and we directed the court to conduct any necessary proceedings. The Circuit Court denied the motion without a hearing. The gist of the motion, 5, the state released the Halbach family suspected human bone fragments recovered from the Manitowoc County gravel pit, there violating a Circuit Court order requiring the state to preserve certain biological material evidence connected to a criminal conviction and Avery's constitutional rights. Motion may raise only jurisdictional, constitutional, and like claims. We consider only the third agreement or argument. Avery alleges that in 2011, the state improperly released the Halbach's bones fragments from the gravel pit, which Avery wished to test to determine if they contained Halbach's DNA and might thereby indicate that Halbach was not killed on Avery's property. Avery argues that the state, by its actions in retaining the bones, has thanks for that super chat. I haven't been paying attention to that. I really appreciate it, but you didn't have to do that. Fails, you got me all. I really appreciate that. That's you did not have to do that. Acts in the bad faith by failing to present potentially explosive evidence. Avery represents that he was not aware and could not reasonably been aware of the release of the bones until after the file of his fourth motion. We will assume, therefore, that this claim is not procedurally barred under. The state argues young blood analysis only properly applies to the destruction of pretrial evidence. We agree generally, but not need to explore this point because Avery claim fails on its own terms. The premises of Avery's argument, the state released to the Halbach family evidence that either apparently or potentially explosively bone fragments from the gravel pit that may have been Halbach's this evidence was first collected was labeled as containing some human bone fragments at trial. However, undisputed testimony of the state's forensic anthropologist was that, on further analysis, the bone fragments could not be identified as human, much less as belonging to Halbach. On this record, therefore, this evidence is not apparently exculpatory. It does not indicate that another person killed Halbach. Apparently exploratory, whatever. Were these having custody over it did not know. Oh, Jesus Christ, this is a bunch of bullshit. Value in evidence was simply an avenue investigation led any number of directions. Nor can Avery establish that this evidence is potentially exculpatory, because even assuming that these bone fragments are Halbach's, Avery does not explain the significance of this fact. Apparent thus to Avery's claim is that if Halbach bones were found in the gravel pit, then she was killed by someone else, but that Avery never explains why he himself would have been unable to dispose of Halbach's remains in the gravel pit. This line of reasoning is wholly speculative. Moreover, Avery cannot show bad faith, meaning the officers were aware of the potentially exculpatory value, usefulness of the evidence that failed to preserve. The officers acted with official animus or made a conscious effort to suppress exculpatory evidence. The second reflects only that the state released bone fragments of indeterminate origin after a direct appeal was fully litigated, when then there appeared to be no direct or immediate need to preserve this evidence. And contrary to Avery's argument, the very fact that the state released the bones does not mean that these are Halbach's, or that the state acted in bad faith to destroy this evidence. The Halbach's family requested the bones fragments for the purpose of its own likely foreclosure, but that's not the best arguments. They're like completely overlooking the fact that they didn't even, like Kratz said, I'm just going to continue reading. I'm starting to get frustrated. On November 9, 2020, we notified the parties to the case that had been submitted in the court rescission and briefs. April 12, 2021, Avery filed another motion with the court to stay appeal and remand the evaluation. New claim. The claim concerns alleged Brady violation, factual basis, which Avery purportedly obtained on April 11, 2021. Specifically, the claim is based on an affidavit by Thomas Sawinski, a Manitowoc motor route driver, who attests that days after Halbach's death, while on his paper route in the early morning hours, he spotted a shirtless Dassey and an unidentified older man pushing Halbach's vehicle down Avery Road towards the junkyard. Sawinski further attests that he delivered the paper. Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch. Sawinski's claimed to have called the Manitowoc Sheriff's Office later that day to report what he had been told, allegedly knowing who did it. He also claims he attempted to contact Avery's trial attorneys after season 1 of Making a Murder, but never heard back from them. When Avery filed his motion, we had already twice stayed his appeal, each time because he asserted that new claims were related to those previously litigated and that would most expeditiously resolve the part of the instant appeal. By this time, Avery filed his new motion. However, he had already evaluated the legal and factual basis for claims already raised. We therefore were and are in a position to conclude that the newly raised claim bears little to no relation to those claims already before us. This is, instead, a distinct issue that the circuit court should resolve on a standalone basis through a new Wisconsin 9706. So basically they're telling them, throw all the shit y'all right now, and you have these little options to resubmit for another motion. Moreover, after the latest motion arrived, while our decision on this appeal forthcoming, it would be an effective use of court resources to now and once again delay these appeals resolution. We appreciate that Avery likely wishes to consider the new Brady claim in the context of claims previously raised, but we must weigh the implicate consideration against these discussed above. Simply put, Avery's appeal cannot continue indefinitely. Accordingly, this decision operates as an order denying Avery's April 12, 2021 motion to stay and remand. If Avery wishes to raise this claim, he must file a new statute 97406 motion with the circuit court. Pursuant, Avery will need to demonstrate why he could not have previously raised his claim, including his "Are you fucking kidding me?" Conclusion. Avery raises a variety of alternative theories about who killed Halbach and how, but the state correctly notes motion, not a vehicle, or to try a case to a jury. The criminal defendant constitutionally entitled to a right to a jury trial, and if convicted, a direct appeal. He or she seeks collateral attack, conviction on constitutional jurisdictional grounds. But the key to any motion are sufficient non-conclusory showings both as to why the issue was not raised in earlier post-conviction proceeding and why the claim was facial merit. These requirements are not optional and cannot be met through broad conclusions or evidence. We express no opinion about the crime. The jury has decided this question, and our review is confined to whether the claims before us entitle Avery to an evidentiary hearing. We conclude that the circuit court did not universally exercise discretion in denying hearings on motions 1, 4, and 5, and not vacating its orders in motion 1, and not reconsidering the ruling on motion 1. As motion 6, the portion of motion 3, the motion to reconsider, raising new claims, we leave open the possibility that Avery may raise these claims in a new statute. We remind Avery, however, that he will need to overcome the procedurally bar on these claims, which includes proving a sufficient reason for not raising them in the 2017 motion. Moreover, Avery will need to satisfy previously discussed specifically requirements before such claims proceed in a hearing. This opinion will be published. Right. So I had a bad feeling. I just had a bad feeling this was going to happen. But it's not the end of the road. It's just another pit stop. Been too many. This shit sucks. I'm sorry, Steven.